Welcome to the LexisNexis Legal Talk podcast, a roadmap for directors in 2024. Today we're joined by Ben McLaughlin and Elizabeth Lane. Ben McLaughlin is a senior partner with Baker McKenzie, advising on mergers and acquisitions in healthcare and life sciences. Ben has just been awarded Lawyer of the Year, Life Sciences, Sydney for 2024. He has extensive experience in advising boards on corporate governance issues. Elizabeth Lane is a corporate lawyer with extensive experience in corporate law and corporate governance matters, and she has acted on numerous private equity and M&A transactions. Elizabeth is the senior legal writer at LexisNexis for Practical Guidance Corporations. Welcome.
Welcome. I'm Elizabeth Lane, and in this podcast, we'll be looking at the challenges and opportunities for directors as they navigate the evolving corporate governance landscape in 2024. We'll be sharing a roadmap to help directors overcome the hurdles that lie ahead, such as managing continuous disclosure obligations, compliance with ESG issues, ensuring directors are cyber fit, and adjusting to the impact of generative AI on business. Thanks for joining me today, Ben.
Hi, Elizabeth. It's great to be here. Thank you.
Thanks, Ben. Directors are facing a rather unique set of challenges in 2024 as they grapple with an eclectic mix of emerging and evolving risks, which stem from the proliferation of ESG issues, as well as AI and cyber risks, amongst others. There's also the volatile economic and geopolitical landscape, which presents its own set of challenges for business. I'd really like to hear your thoughts on how you think the current economic climate is impacting business, and how is it affecting directors to shape company strategy and their governance frameworks this year?
I think it's fair to say that 2023 was a challenging year for business. In M&A, we called it the year of busted deals. But there are contrary measures, of course. The ASX is at near record levels. Australian companies and directors have generally faced difficult business conditions. And given that there is this increasingly demanding regulatory environment, it seems that 2024 will also be a challenging year. Obviously, the geopolitical situation is confronting and volatile. Economically, high inflation and related high interest rates have been problematic for both business and consumers. And there are mixed signals as to whether this is finally coming under control. There are also constraints on the supply side, including pricing, labour shortages, and various other global and local pressures on supply chains. This volatility makes it harder to do business, and it is more difficult for directors to forecast and plan for the future, particularly in an environment where they face increasingly active regulators and increasingly activist shareholders. Directors will certainly need to ensure they're addressing a diverse range of risks and opportunities this year.
That's right, Ben. And I think on top of the challenging geopolitical and economic landscape, directors are also finding themselves facing a pretty unique set of environmental and technological hurdles this year. Let's address the green elephant in the room, ESG. Over the past couple of years, we've seen the exponential growth of ESG issues, and companies need to be careful to avoid greenwashing, and there's increasing pressure to set and implement net zero targets. On top of that, businesses are also preparing for mandatory climate reporting later this year. ASIC has emphasised that climate change is a material risk that needs to be regularly examined in respect of existing and emerging risks, but also we've seen that nature risk and biodiversity loss also now appear to be part of the matrix of directors' duties. It turns out that ESG is a perpetually evolving area and becoming increasingly complex. And Joe Longo, the ASIC chair, said that he considers ESG issues to be driving the biggest changes to financial reporting and disclosure standards in a generation. ASIC has obviously strongly signalled that it will be watching companies closely to ensure they're meeting their obligations in these areas. How do you think directors can prepare for the ESG challenges in the year ahead?
The ESG revolution is certainly speeding up, and boards are under increasing pressure from investors, stakeholders and regulators to not only manage but embrace ESG challenges and opportunities. It's not surprising that Australian directors see climate change as the most important long-term issue for the government to address.
Yes, and I think that managing the risks and opportunities of climate change will continue to be a big focus for directors this year. And perhaps one of the most important developments will be the rollout of the mandatory climate-related reporting standards, which is expected to be live from 1st of July. We saw last year that the International Sustainability Standards Board released its own standards, and Australia's now echoed this shift to mandatory climate reporting, and there's currently some public consultation underway. We've seen the Australian Accounting Standards Board release their equivalent standards for Australia, and the government introduced some legislation earlier this year to follow suit. What do you think companies need to do to disclose under the new mandatory climate reporting regime, and how can directors take action now to prepare for the new regime?
While we wait for these mandatory climate reporting laws and standards to be finalised, ASIC has urged directors to be actively preparing for the new standard in climate reporting by running gap analyses of their company's current governance structures, reporting capabilities, and climate-related competency of the board and senior management as well. Under the imminent climate reporting regime, companies will need to disclose their greenhouse gas emissions estimation methodologies and international climate change commitments. For example, entities will need to disclose climate-related financial disclosures in a separate sustainability report as part of their annual report and obtain an assurance report over the sustainability report from their financial auditors. The AICD has released guides for directors to prepare for mandatory climate reporting, and directors would be well advised to also seek expert advice, as the reforms may require significant upskilling and changes to existing governance and reporting frameworks for some organisations.
Yes, and in addition to the mandatory climate reporting standards, we've also seen that directors are going to need to keep in mind that they need to look at their disclosures in terms of nature, biodiversity, but also other sustainability and social issues in the future, such as modern slavery. For now, nature and biodiversity seem to be a key focus, and directors will need to understand how biodiversity loss and nature impact upon their business. We've seen various standards released in this regard. There's the Task Force on Nature-Related Financial Disclosures, as well as the CCLI's report on biodiversity risk, which looks at the illegal implications for companies and their directors. The government also introduced nature repair legislation at the end of last year. What are the key things that directors need to think about in terms of the impact of nature and biodiversity loss in terms of the risks and opportunities for their business?
Elizabeth, it's critical for boards to consider their organisation's nature and biodiversity impact, and in particular, how nature-positive solutions can contribute to achieving organisational climate goals. If they don't, they risk breaching their directors' duties and being subject to significant penalties. On the nature front, we saw the publication of the Hartford Davis legal opinion, arguing that Australian directors' duty of care may oblige them to consider, disclose, and manage their company's nature-related risks, which means that directors need to look at the potential threats arising from the company's dependencies and impacts on nature. This opinion follows a series of earlier opinions that similarly argued directors were obliged to consider climate-related risks, and it reflects the global movement of ESG regulation beyond climate to include nature and biodiversity.
Yes, and another, I guess, ESG green bingo word has been greenwashing, which continues to be a big focus for business this year, and ASIC is carefully surveying this area as well. What are some key considerations for directors as they undertake marketing and fundraising activities this year?
Yeah, Elizabeth, you're so right. It definitely is a bingo word. ASIC and the ACCC have reiterated that they will continue to focus on greenwashing as a key enforcement and surveillance priority this year, especially in relation to listed companies, managed funds, and superannuation funds, which are increasingly making claims about their ESG credentials. For those who may not be familiar with greenwashing, it is essentially misrepresenting the extent to which a product, business, or investment is environmentally friendly, sustainable, or ethical.
Yes, and I guess in terms of looking at words that are being used and a kind of trigger bingo words, where the key terms are carbon neutral, clean, green, ASIC will certainly be watching closely and may even require companies to issue corrective disclosures or issue infringements if it concludes that the companies have used those terms in a misleading way. Directors also need to ensure that their net zero statements and targets and claims of decarbonisation are made on a reasonable basis and that they're factually correct. And it would be a good idea for the board to ensure that senior management are on the lookout for these kinds of statements in prospectuses websites, but also in their market announcements.
Yes, Elizabeth, I agree with you. ASIC has demonstrated that it will not hesitate to take action against companies if they are found to be greenwashing. Last year, ASIC launched 3 separate legal actions in the federal court against companies for greenwashing conduct, as well as issuing a number of infringement notices. It remains to be seen whether ASIC will pursue directors personally in relation to such breaches, but in any case, it is critical for directors to ensure their organisation's compliance when making environmental claims. Both ASIC and the ACCC will continue their crackdown this year, with ASIC zeroing in on the superannuation industry and the wholesale green bond market in particular.
Yes, and if we turn away from the green setting for a minute and now look towards the technological revolution, I guess, that has taken over business and society, I guess there's been a heightened focus on the need for businesses, in particular, to effectively manage cybersecurity risk in recent years, due to the increasing rise of cyber attacks on many different businesses across various industries. Cybercrime seems to be the key issue keeping directors up at night, according to the Director Sentiment Index survey, due to the significant increase in rise of these breaches. And also there's been a big increase in regulatory scrutiny and enforcement. Not surprisingly, the number 2 issue for directors is legal and regulatory compliance. But more concerningly, ASIC's CyberPulse survey last year found that 44% of companies don't manage third-party or supply chain risks. 58% have limited capacity to protect their confidential information adequately or cannot do so currently. And a third don't have cyber incident response plans, nor have 1 in 5 adopted a cybersecurity standard. This may indicate that many companies are not cyber fit and they do need to increase and improve their cyber resilience. There's obviously a lot at stake for companies if they get this wrong, and we've seen the reputational and financial damage that's been suffered by companies recently who are not ready to respond to cyber attacks. What do you see as the key messages for directors navigating cyberspace this year?
Cybersecurity risk management will remain a critical issue for boards now and in the future. Last year, we saw that cybersecurity breaches resulted in several class actions and regulatory enforcement against companies. ASIC has repeatedly signalled an increase in its regulation of cybersecurity risk management and prosecution of cybersecurity failures. Of particular concern to directors, ASIC has made it clear that cyber risk management forms part of the director's duty of care and diligence, and directors who fail to implement adequate cybersecurity measures for their business are exposing themselves to potential enforcement action by ASIC.
Yes, and the government has also shown its commitment to improving the cybersecurity laws to support Australia as we see the growth of the digital economy, and also to stem the tide of cyber attacks and protect consumers from the damage and loss that can stem from these cyber attacks. It's released a cybersecurity strategy and action plan late last year, and the current proposal by the government may include a no-fault, no-liability ransomware reporting obligation, which is designed to encourage information sharing by businesses, as government has found that a lot of businesses are reluctant to come forward. It may be quite a while before any of these new laws and initiatives are implemented. The directors certainly need to ask themselves what they can do now to ensure that they are cyber fit.
Yes, Elizabeth. The key message for directors is to ensure that cyber risk is being effectively managed by the company and that it is included in the company's organisational risk management framework. As you mentioned, ASIC recently reported on significant gaps in the cyber capabilities of Australian companies. And Joe Longo, ASIC's chair, has noted that directors must ensure their organisation's risk management framework adequately addresses cybersecurity risk and that controls are implemented to protect key assets and enhance cyber resilience.
Yes, and Joe Longo has also encouraged directors to read the AICD's cybersecurity governance principles, so hopefully a copy is nearby on the desk of every director. A key indicator of having an effective risk management framework is that the board has set clear roles and responsibilities for dealing with cybersecurity within their business. And I think it's very important that there's clear board reporting by engaging with management. The board is actually receiving regular updates if there are any emerging cyber trends.
Yes, that's right, Elizabeth. I think it's also very important that the company has a comprehensive cyber strategy which identifies the key digital assets and data of the company, as well as a cyber incident response and recovery plan.
Yes, we've seen the devastating impact on boards where they're unprepared for cyber attacks. And this is obviously an area which ASIC and the ASX are keenly watching in terms of the context of disclosure. Given the likelihood that all companies may experience a serious cyber attack at some point, directors do need to have a cyber incident response plan which has a clear disclosure strategy for informing the market. That leads us to our next discussion point on how directors can effectively manage their continuous disclosure obligations. Continuous disclosure is an integral part of directors' duties for those directors who are on the boards of listed or disclosing entities. The regime was significantly amended in 2021 due to the concern that opportunistic class actions were frequently being brought against companies with detrimental effects on the shareholders of those companies, as well as the availability and cost of directors' and officers' insurance. The effect of the amendments is that directors are now only exposed to civil liability for breaches if there's a failure to disclose price-sensitive information and that failure to disclose results from knowledge, recklessness, or negligence. This is otherwise known as the fault element. And prior to this test, the reasonable person test applied, and ASIC or a plaintiff alleging damages for a failure to meet disclosure standards had to prove did not have to prove state of mind to bring these proceedings. There was a government review of the amendments, and that was required as part of the amendment protocol. And the government is seeking stakeholder views on the amendments. And as part of those stakeholder consultations, the AICD has submitted that the reforms have actually brought Australia's disclosure regime closer in line with major overseas markets, such as America and the UK. And without a fault threshold in our disclosure laws, there's a heightened risk of opportunistic class actions. As a result, they've supported keeping the amended laws as they are, especially given the challenges and complexities of disclosure in the areas of cybersecurity and the climate reporting landscape. Do you agree with this sentiment, Ben?
Yes, I think you've summed it up very well, Elizabeth. The government has 3 months to respond to any recommendations made in the report on the fault test in the continuous disclosure regime. Although the review was independent, given that the amendments were strongly opposed by Labor and the Greens, I think there's a reasonable possibility that this year we'll see a return to stricter continuous disclosure laws, and the fault test may be replaced with the previous responsible person test. If the previous test is reinstated, this would lower the bar for liability and, in that sense, increase the risk of regulatory action and also class actions in relation to alleged continuous disclosure breaches. I would suggest, though, that ASIC and class action plaintiffs are most likely to pursue strong cases that have a similar chance of success under either form of the test. But perhaps we'll see occasional action succeed under a reintroduced reasonable person test that might have failed under the current fault test.
I agree, Ben, and I think regardless of whether the fault test continues under the continuous disclosure regime, directors will still need to continue to approach disclosures with great care, especially in relation to the issues we've been discussing, such as cyber attacks and ESG issues. And boards will need to ensure that their companies' policies and processes for identifying and escalating price-sensitive information are really robust and effective. What are your thoughts on this?
Yes, the continuous disclosure regime is a significant ongoing concern for the boards and disclosure committees of listed companies and other disclosing entities. It's a challenge that has increased in recent years and is probably only going to grow in the year ahead. ASIC has been quite active in policing these rules and now includes continuous disclosure breaches as one of its, quote, enduring enforcement priorities. So that puts it in the same category as insider trading and market manipulation. Continuous disclosure has always been an area where careful judgment is needed to determine whether information is materially price sensitive and where decisions need to be made quickly so the company can make either a market announcement or otherwise request a trading halt. A common area where these decisions arise and companies can run into trouble is in giving or updating earnings guidance. And as you mentioned, those considerations will now extend to include climate reporting considerations and cyber resilience.
What's at stake at the end of the day for directors if they get this wrong?
The pressure on boards to make the right call on disclosure is particularly severe, given the potential penalties for breaches of continuous disclosure laws. A few years ago, the maximum financial penalties were $200,000 for individuals and $1 million for companies. Not small, but much less than the multi-million-dollar penalties now faced by directors and potentially hundreds of millions of dollars for their companies. That increase was made in 2019, but we haven't yet seen its full effects, given how long these proceedings can take. Some of the more prominent recent cases relate to pre-2019 conduct. So the penalties are still relatively low, but we're starting to see some more substantial penalties and can expect this to continue. As well as potential liability directly under the continuous disclosure laws themselves, there is also a growing trend of ASIC pursuing directors, often successfully, for what is called stepping stone liability. This is where a primary breach is made by the company, so a breach of continuous disclosure requirements, and directors are found to have breached their fundamental duty of care by failing to prevent the company's breach. This new principle gives ASIC and aggrieved shareholders another and potentially easier avenue for claims against directors.
One of the big changes for directors this year is the emergence of generative AI, which we saw come into force last year as definitely the most significant technological development. And it's certainly being embraced by the business community as well as consumers. We've heard the arrival of AI being compared to the invention of electricity due to the dramatic impact on the way that we both work and the way that we live. It's apparent that AI has the dual capacity both to disrupt and also create new opportunities for businesses, and potentially very exciting ones at that. AI also, though, poses significant risks to both business and the community. We've seen failures from the AI systems such as bias, discrimination. There's also privacy issues and the expected job losses that will flow from the implementation of AI. At LexisNexis, we've just launched an Australian commercial preview of Lexis Plus AI, which is a generative AI solution to transform how our clients do their legal work. And we're seeing this kind of AI ingenuity across all sectors of the market. What do you think are opportunities for directors here, and also what are the risks that they need to think about as AI takes over society?
Yes, good questions, Elizabeth. So generative AI presents pivotal opportunities and challenges for directors in guiding their businesses to take advantage of the new tech opportunities, while also guarding against the risks. Last year was very much an exploratory year of understanding Gen AI and how to safely leverage it. And this year, we will no doubt see further leaps in the technology. I think we can also expect to see a regulatory framework emerge that will both mitigate risks and support local innovation in AI across a range of industries. The government will be focusing on defining high-risk AI for mandatory regulation and also developing voluntary AI safety standards and further consultation with stakeholders and advisory groups.
Yes, last year we saw the government invite consultation on how we can mitigate the potential risks of AI and also support safe and responsible AI practices. And it's now released the Australia's 8 AI ethic principles. It does seem that for now the government will look at existing laws and see how they can be repurposed to deal with AI and use existing regulatory pathways before the government moves into creating specific legislation. Directors do need to understand, as you mentioned, how AI impacts their company and its obligations, and they need to look at how competitors are using AI as part of their examination of the risks and opportunities. that AI presents. In one sense, directors will simply apply the same general oversight approach in respect of their management, compliance, risk and disclosure framework. However, AI does seem to present a very unique set of risks and opportunities and arguably requires special consideration by directors. Directors need to consider the ethical responsible use of and development of AI. And one example of this is obviously in the context of recruitment or data analysis, as we've seen that AI is particularly prone to bias when it collects and analyses certain data.
Yes, the role of directors in relation to AI was emphasised in late January this year in a speech by ASIC Chair Jay Longo, who said, as companies increasingly deploy AI, this is something directors must pay special attention to in terms of their directors' duties. Mr. Longo also noted that ASIC is already reviewing the use of AI in the banking, credit, insurance and advice sectors and is prepared to act early to deter, quote, bad behaviour in this area. Practically speaking, directors of most companies should ensure their company has a strategic plan for whether and how it intends to pursue the opportunities presented by AI, whether that's by offering AI-enabled products or services to customers and clients, or simply by integrating AI systems into internal processes. For those companies that do integrate AI tech into their business, directors should also be overseeing their company's management of related risks. These will vary significantly, depending on whether the company is offering AI to the market or simply using it internally. It may relate, for example, to privacy and copyright issues in the data used to train an AI system, the risk of cyber attacks seeking to obtain such data, or other issues around bias, accuracy, and quality of information.
Yes, I agree, Ben. And I think it'll be critical for directors to look at the impact of how they're using AI in their business in terms of direct impacts on employees, customers, key stakeholders, obviously the environment, and they need to be thinking about disclosure around these issues as well as the threat of cyber attacks. Boards will also need to closely monitor how AI evolves, as it seems to be moving at a dramatic pace, and they'll need to ensure that they're tech savvy and have the necessary agility to pivot and adapt their protocols and governance frameworks as the AI technology evolves. I'm sure directors aren't keen to be replaced by synthetic AI directors in the future.